Okay, what else? And by the way, most questions at the last minute are not very good. And I don't say this to insult you, but generally it's out of pure panic that these questions exist. And most times I say, relax, don't worry. But the quality of questions declines precipitously as you approach exam date. I've charted that with some accuracy. So, but I'll do the best I can. All right, anything else? Yes, ma'am.
Okay. So one of the reasons why I didn't do that great on my Property 1 final was because under exam pressure and like trying to read what was going on in the story, not being familiar with the movie, I didn't know what was going on because I kept going back and forth between my head and whatnot. So I was wondering if you could use a subject that everyone knows, like the college movies. What? I don't know that.
All right, I'll answer the question. I actually think a lot about this. There was absolutely nothing in the exam that required you to see the movie. Nothing. No, I mean that sincerely. I would never ask an exam which requires you to have seen the movie in order to answer it. I think that'd be inherently unfair. So I give you all the facts you need to know. If you know the movie, that's fine. If you don't, it makes no difference. But I appreciate the question. Thank you. Yeah, I remember, this wasn't at South Texas, but I remember a couple years ago, many years ago, a professor had given an exam, and one of the characters in the exam was Justin Bieber, who at the time was under the age of 18. And it was a capacity question, contracts, and you want to say, oh, he's a minor. And people didn't know who the hell he was. So that is an inherently unfair question. I would never do that. Okay? Sorry, did I just say the word H word for a little kid? I'm sorry. Sorry, Matilda. I once did the case of Cohen versus California in front of someone's kid, and you can just Google what that case was about. Just Google Cohen v. California. Okay. Yeah. Yes, keep coloring. Good. Sorry. All right. What else? What else? What else? All right. So my goal for today is I want to go over the first question from the fall 2017 exam. Then I will take all of your questions. I will stay here as late as you need me to. If you want to come to the office afterwards, I'll be here till 9 tonight. Well, I have class in the middle, but I'll be here till I guess 7:30. Then after that, till you make me go home. But I want to try and get as many of your questions out of the way. This is probably the last time I'll see most of you, so it's been a pleasure. It's been fun for a year straight, and maybe I'll see a few of you in the spring. I'm actually writing my syllabus now, First Amendment for the spring, so some of you hopefully can take as well. All right, so by this point, you know the format. If you don't, you should. 2 questions, right, each with a 1,000-word limit, no more than 2,000 words total. Make sure you do a word count for each question. So if exam question number 1 is like 800 words and question number 2 is 1,200 words, that doesn't work. You need to have a total of no more than 1,000 per question. And I do a word count separate for each question. Okay? Please pace yourselves. The number one reason why people don't do well is they don't finish. They leave stuff blank. The advantage for my exams is they are predictable. You know with certainty exactly what you're getting. You're getting a fact pattern, roughly 1.5 pages in length, followed by 5 prompts. If you have 30 minutes to read the question, that means you have an hour left over for 5 parts. That means 12 minutes apiece. So please pace yourselves. The best way to work these issues through is by taking my old exams. They're all there. You'll find, more so than Property 1, but Property 2 more so, the topics change. This is now, I think, the 3rd or 4th edition of the casebook I've used, and cases have come and gone. So there might be some cases you don't know, which is fine. But the more important part is learning to spot the issues. Like, oh, we never did that case. That's a very important skill. And please use the word count. I hope you don't handwrite. I don't think anyone actually handwrote the midterm, which was I think that was good. But please try to type and convey your ideas concurrently. Okay. So for the midterm, for the final in this class, it's okay. For the final in this class, you have to keep in mind a couple things, right? In Property 1, basically everything was common law. But in Property 2, there actually is a distinction between the common law rules and the modern rules. And you need to keep those in mind. One thing to keep in mind really is where those differ. So one way that you can, I think, better prepare for your exams is to go through your notes and flag the areas where the common law rules and the modern rules differ. And that happened at a number of junctures throughout the semester. So you should have that list handy. All right, so here we go. I'm going to start reading it. Okay? Can everyone see it okay? I know it might be a little bit tough to read. I mean, a little bigger. I don't want to scroll too far. Okay, that's better. Okay. Everyone read that okay? Yeah? Okay, very good. Thank you. All right, so let's do part one. It says, okay, instructions. You are a law clerk for the Chief Justice of the Wazangamet Supreme Court. Again, if you don't know what that is, it doesn't really matter. It's a Harry Potter thing. You are asked to prepare a memo of number of 1,000 words concerning 5 property disputes on Castleacre, Alleyacre, and Crossacre, involving Potter, Ron, Hermione, Dumbledore, and Voldemort. Okay? So you have 3 properties, 5 names. This jurisdiction applies all American common law rules and is bound by the U.S. Constitution. All right, so now you know you're in a common law jurisdiction. And the fact that I'm mentioning the Constitution of the United States should give you a very important hint. I am going to ask you about the Fifth Amendment, a takings question. I don't know what it is, right? But the only reason why we've referenced the Constitution in this class is for a takings question. That's why I put that in there, right? What I suggest you do differently is read the questions. Here they're not very helpful. First one says, how should the court resolve Potter and Ron's competing claims over Castleacre? Because it doesn't really give you too much. Second, how should the court resolve Potter's appeal concerning the denial of a special exception? Okay, you have a zoning question, right? Remember, there's special exceptions, right? There are variances. What's the difference? A variance is based on a hardship. A special exception is when the legislature sets specific conditions. If you satisfy those, if you check the boxes off, you get to build what you want to build. Okay? Then we have the third question. Should the court allow Dumbledore to rely on the 1895 easement to operate the Hogwarts Express? Okay, so that's an easement question, but also something from 1895. So we have things about what happens with old easements, with abandonment, other doctrines like that. Okay, number 4. Regardless of how we answer question number 3, how should the court resolve Voldemort's claim brought under the Fifth Amendment's takings clause? Okay, so we have a takings question. And number 5, how should the court interpret the sign that says no vehicles in the park in deciding whether Potter is guilty of a trespass? All right, this is your policy question. I think we mentioned this in class. I sprinkle lots of these questions through the semester, and when I write the exam, I like to just pluck one out and see how you guys run with it, which gives you a lot of room to run or a lot of rope. Never mind. So we go back up to the top. So we read. It says, and this, again, the exam's pretty short. You'll notice my older ones were much longer. There's a skill to writing an exam, and it took me a couple years to figure it out. More recently, they're all about a page and a half in length, which might sound easier, but when I give you less facts, it's harder. But it's writing just enough facts to get you to the finish line, but nothing more to give it away. All right, so let's read. It says, Hermione, the record owner of Castleacre. Okay, so that should tell you already that there might be a dispute over who actually owns it. Promised to give the property to her friend Potter and Ron if something bad ever happened to me. Now, that's a little bit weird, right? What exactly is that? It's not a present interest. It's some sort of a future interest, but it's with a conditional. Now, I'm not asking you fee simple, that stuff. That's not why I'm asking it here, right? But some sort of future interest if something bad ever happens to me. Okay. And also, it's a co-tenancy, right? There are 2 people involved, not 1. Potter and Ron understood that to mean if she became ill. Hermione understood it to mean if she died. Now, we actually did a case like this, right? Remember Rosengrant, right? Yeah, that case, right? And then you have this case where, I forgot the name. You have the elderly couple, right? And the son-in-law was taking care of them. And they said, you'll get Blackacre if anything ever happens to us, right? And there was actually a dispute over what that means. Does it mean when they die? Or does it mean when something bad happens to them? So keep that case in mind. So it says, soon Hermione became ill and told Potter, if you take care of me during my dying days, I will give you and you alone Castleacre. right? So now we have competing oral statements, right? Can one statement disclaim the other? In other words, if I make an oral promise to give you something, can I make another oral promise to revoke it? Now notice these are all oral. We have the statute of frauds to keep in mind, right? Where you need to have property for real estate in writing for precisely these sorts of reasons. Okay? But now we have a writing involved in the next sentence. It says, Hermione hands a deed to her owl and instructed the owl to secure the deed until she dies, and then to deliver it to Potter and no one else. The owl, who was very loyal, would follow the directions precisely. So is this a conveyance in the present moment, right? In the case we studied before, Rosengrant, they handed the deed to him, they handed it back, and they put it in the banker's desk, right? The banker's vault. But at any time, the original grantor could retrieve it, could bring it back. And we said because there was a chance to retrieve the deed from the bank, there was not a present conveyance. But here it's a little bit different. They put it in this magical owl and just assume my facts as I give it to you, right? Assume the facts are there. Hermione can't retrieve it. It's basically being stored by the agent, almost like a bailment if you want to think of it in that sense. Not we didn't do it this semester, it was almost like a bailment. But the instructions are to deliver it when she dies. So at that point, it's kind of like a life estate, right? With something, a remainder perhaps. But we don't know how Ron understood it, or how Potter understood it. Then the question continues. Shortly before Hermione's death, Ron, trafficking hell, I forgot this one, took the deed, right? Okay, so how do we think about that, right? He took the deed that was already delivered. Was there already delivery for purposes of some sort of estoppel or fairness? How do we understand that when someone robs a bank, for example, and takes a deed that's already been given to someone? Does it already belong to the recipient, or does it belong to whoever has it in their hands? Okay. Next, after Hermione dies, Ron, with deed in hand, claims ownership of Castleacre. Potter sues Ron in the court's original jurisdiction, the quiet title. All right. So there's a lot going on here. I sometimes ask these sorts of questions where there's so many competing factors. It's really tough to figure out which way is up. I don't think there's necessarily a correct answer here. I don't think there is, but I want to see how you grapple with it. Let's take a look at what the A+ student did. And I don't have a memo for this one. I'm sorry. I only started doing the memo last year with your section. Okay, so this is the A+ answer. Let's see what this person wrote. For delivery of a deed, there must be intent that is presently operative, right? You have to have a present intent to give the deed. A valid conveyance requires actual constructive delivery of a deed to a grantee or third party, and an intention by the grantor to divest himself of the conveyed interest now. Okay, I think that's probably true here because Hermione didn't reserve any right to retrieve it or reclaim it. I think that's correct here. Like in Rosengrant, where the elderly couple intended the deed to be transferred upon their death, the intent of Hermione is also not to divest herself of it until she dies. Hermione giving the deed to the owl, instructing to hold the deed until she dies, like the couple in Rosengrant, giving the deed to the bank to hold until death, with instructions to then give it to the grandson. Ron will argue that Hermione had right of retrieval from the owl at any point until death, and since Potter never recorded it, the property must go through probate according to law. Although Ron adversely captured the deed, I don't think I call it adverse possession. I think it's theft. He will not acquire, okay, that's fine. He will not acquire it by adverse possession unless he has actual possession, which he does. Not sure about the adverse possession. Weird analysis there. I don't know if I agree with that one. Again, even the A+ answers aren't perfect. I think if I remember this one last year, I got maybe a 92 or 93 of 100. So rarely do people ever get everything correct. This wasn't a hybrid answer, and I started doing that also to alleviate this problem. Although we don't know the statute of limitation required, it does not seem he will meet the continuity requirement because Potter immediately sues after Hermione dies. The court will like a rule that there was never constructive or active delivery. Okay, so I think there's some stuff missing here. I'm sure you see stuff as well. I think one of the first things that's missing here is you have this initial conveyance to both Potter and Ron about if something ever happens to me, you can have this, right? What's the problem? We have two types of gifts. We have gift inter vivos and gift testamentary, right? Gift inter vivos means during life, and a testamentary gift means a gift after death. In order to give a testamentary gift, what's required? You have to satisfy the statute of wills. And to satisfy the statute of wills, you must have a writing, right, that has two witnesses, right? There are formalities you have to follow. Is this conveyance? I'll give this to you if something bad ever happens to me, right? Is that a conveyance inter vivos or testamentary? Again, I think it depends how you read it. Is this, we're giving it to you, if I get sick, or when I die? If it's when I die, it's not a valid conveyance at all. You have statute of fraud problems no matter what, right? And there's some exceptions to statute of frauds. But you have statute of frauds and you have statute of wills, right? They're stacked one on top of the other, right? So even if you're a candidate of statute of wills, you still have to deal with statute of frauds, or vice versa. So you should have been talking about both statute of fraud and statute of will in this question. And there's a second issue is, does the second oral, the oral statement get rid of the first one? Well, if the first one's not valid, then the second one with the owl's fine, right? In other words, if the first conveyance is not valid because it's a testamentary gift, then the second one is fine. But if the first one's valid, that means that both Ron and Potter have an interest in Blackacre, or Castleacre, I'm sorry, and you can't get rid of it, right? You can't revoke a stick already given in a bundle. Ron has that stick. So at a minimum, this question, you should talk about a few things, right? First off, does it satisfy statute of frauds? Second off, does it satisfy the statute of wills, right? Was the initial conveyance valid? And then second, was the owl conveyance a valid delivery? Was there intent? Could they reclaim it? And that's the Rosengrant case. Yeah, I don't know where they got adverse possession from. It's a very strange answer. I don't remember not liking that one very much. But I think those are the big issues: the statute of frauds, statute of wills, and also Rosengrant with delivery. Okay. Questions on number one, please. Questions on number one. You can see why I switched to the hybrid A+, because it drives people crazy when you see stuff that's not exactly right. But there's never a perfect exam. It doesn't exist. I've never given 100 in this class in anything. It's understandable. You're under pressure. You're scrambling, right? Here, you're all calm and whatever. You can answer these questions under clarity. Anything in question number one? Nothing? Going once? Twice? Okay, I'll move on. Let's do question number two, please. Where is it? Okay. Here we go. Okay, so it says, Potter owns a store on Alleyacre that sells brooms. In the right hand, these brooms are mere cleaning devices. Oh, by the way, do you know where the, oh, this is actually somewhat disturbing. Do you know where the image of witches and broomsticks came from? Anyone know this one? It's actually a little bit disturbing. Oh, God. How do I do this? Damn it, why did I say this? So, back in the olden times, people used different kinds of drugs. And they always did, right? And one way to consume a drug is through your mouth, right? And that can make you very sick. So there was another way to do it by having it absorbed through body parts. And broomsticks were used for that. And I'm going to leave it there. Just Google it. Yeah. So basically, you take the broom and put it inside the brew, and then, yeah. I'm serious. And that's where the image of the women with the brooms and the witches came from. And, you know, yeah, yeah, it's true. Question number two. Potter owns... People are fiercely Googling that right now, I know. Potter owns a store in Alleyacre that sells brooms. In the right hands, these brooms are not mere cleaning devices. That's what made me think of it. Wizards and witches can, through the use of magic, fly on brooms, right? So if you've never seen Harry Potter, they can fly on brooms. The legislature becomes concerned that Potter Store is attracting so many wizards and witches onto Alleyacre because they're considered dangerous. Okay, we actually talked about this, right? When we discussed something not quite broomsticks, but we discussed regulation of adult bookstores, right, and strip clubs and the like. And the reason why the government can restrict these entities is not because of their content, or not because their pornographic materials are bad. It's because they attract secondary effects, such as criminals in their neighborhood. And that's why they can say that you can't have these adult bookstores, for example, in residential communities, right? So here I'm using something much more innocuous, brooms and witches, whatever, but it's the same idea. So the legislature promptly enacts a new law. It says within 30 days, all property owners must obtain a special exception from the zoning board to continue operating a dangerous business. Okay, so again, the reason why it's dangerous is not because the broomsticks themselves are dangerous, but attracting these wizards and witches near the store. Okay? So you start thinking about what are special exceptions. A special exception is specifically designed by the legislature that if an applicant checks certain boxes, meets X, Y, and Z criteria, they're then allowed to keep their business. Okay? But the key point here is within 30 days, all property owners must obtain the special exception. There's no grandfather clause, right? There's no grandfathering of prior non-conforming uses. Instead, everyone must come up to speed immediately within a month. And this comes to mind the amortization case. What's amortization? When the government says you must come into compliance within X number of days. And we had the Pennsylvania case, the Northwest Distributor case, which said that under at least the Pennsylvania Constitution, all amortization principles are invalid. Now that's the state constitution. You might remember there was a concurring opinion that said they might be reasonable elsewhere. The federal constitution doesn't really speak to this issue, but you do have to discuss amortization. Okay, I'll keep reading. Potter requests such a special exception from the zoning board. The zoning board holds a hearing at which evidence is presented that the use of magic by wizards and witches poses a threat to public safety. The board rejects Potter's evidence to the contrary that wizards and witches actually promote public safety. After the hearing, his special exception is denied, and then he appeals. So a couple things are going on here, right? When you have a variance, the city, the zoning board, has to make certain findings on whether there's a hardship, right? And that's usually a very subjective determination. But with a special exception, it's supposed to be black and white, right? There's not much discretion on the part. We did one case where a special exception turned on whether something's in the general welfare, right? That's far too broad. Here you have the zoning board trying to decide what is in the, how do I phrase it, public safety, right? Public safety is a very broad concept. And we don't expect zoning board members to decide what's public safety. So here the legislature didn't give enough guidance, didn't delegate enough specificity to the zoning board to decide whether these special exceptions are warranted or not. Okay? Yeah?
Did you say that you don't expect the zoning board to decide public safety?
I think that's far too broad of a standard for the zoning board to decide. Right? They need very specific guidelines. Like, imagine the questions like, you need to have a yard of no more than 15 feet, right? They can measure 15 feet with a ruler. They can't measure public safety in the same fashion. Okay? So I think here you should be talking about a couple different topics. One of which is the standards for special exceptions. We talked about secondary effects, and that's why they can regulate the usage. We talked about amortization and the Northwest Distributor case from Pennsylvania, and whether there's a proper delegation to the city zoning board about how to determine what is in the public interest, or public safety. All right, so let's take a look what the A+ student wrote down. Okay. This person wrote, Since Potter was previously conforming to zoning laws, the change in regulation would render his use as a grandfathered pre-existing non-conforming use. Poor sentence. Don't use use and use twice in the same sentence. I don't like it. Yeah, generally try avoid using the same word in the same sentence, and in back-to-back sentences, try using different words if to the extent you can. Makes it a little bit easier to read. Under the common law, Pennsylvania versus Northwest Distributors, again, it's a state case, but fine. An ordinance which has the effect of depriving a property owner of a non-conforming use is per se confiscatory. And requiring an amortization period is never reasonable, unlike ML. ML. I don't know what that was.
Is that the modern law?
Modern law. Modern law. Don't do that in your exam. ML. If I have to guess your acronym, you're working too hard. You're saving one word. ML. Modern. Modern law. Modern law. Okay. Modern law. Okay. All right. I think that's right. Per se confiscatory means an automatic taking, right? That there's no balancing that goes on. Okay. But grandfathering exception does not apply if your use is a threat to health, safety, morals, or general welfare, which is in the police power. Correct. The exception there is, again, the zoning board can't make decisions on what the police power is. They have very limited, narrow guidance to grant these exceptions. Here, the brooms are considered dangerous and falls in this exception. I'm not crazy about that. Okay, next sentence is correct. But the special exception is unconstitutional, and the zoning board is acting ultra vires. That is beyond the scope of their authority. That much is correct. Then they cite Cope. Cope was the spot zoning case, I think, right? There are no specific guidelines or factors to determine whether you can continue to operate a dangerous business. Good. Unlike variances, zoning boards have no discretion to grant or deny special exceptions. Good. They're predictable. Very good. And they actually show, this sentence I like because it shows when you're paying attention. The reason why variances exist is to deal with unpredictable problems, right? Things come up you can't imagine before. Whereas having, I guess in this town at least, dangerous brooms is something you can anticipate in advance and you can legislate with specificity. And in fact, in these facts, you did have specifics, right? You had specific problem and they enacted a statute in response to it. Okay? For a special exception to be valid, there must be specific factors that must be met. Bless you. For it to be granted, and since there are no factors here, and the zoning board uses discretion, they're acting ultra vires, not in ultra vires. They're acting in ultra vires, and the ordinance is facially unconstitutional, and it cannot be enforced against Potter. That's a pretty good answer. I would have liked a little bit more about, how the secondary effects works, and maybe how some of the why it's ultra vires and why it's not a delegation. But it's a pretty good answer. I like it. Probably get 9 or so. Questions number 2.
So for a variance to,
Yeah. I'm sorry. Say it again, please. I didn't hear the first thing you said.
for a variance to be granted, it has to be unpredictable or predictable.
It's not for a variance to be granted. The reason why a variance may be granted is because it concerns something that's unpredictable, that couldn't have been predicted, right? When you have the legislature actually enact the special ordinance statute, that means it's something that's predictable. And the legislature, not the zoning board, gets to decide the factors for granting it or not. That makes sense? Right, again, but the entire purpose of variance is to deal with an unpredictable hardship. Here, when the legislature acts in response to a problem, it's by definition not unpredictable. Yeah. Here in this case, the legislature enacted the statute in response to a problem. Okay. By definition, it's predictable because they dealt with it. Mm-hmm. And they need to give specific guidelines of when and when not the permit can be granted, the exception can be granted.
Didn't we have a case that was about, I think it was the adult store and the day limit? So isn't it, if they give like too few days, like couldn't you argue the 30 days isn't enough, so that's unconstitutional?
Yeah, right. So the Pennsylvania case, that's when we're talking about the Northwest Distributors, was based on the state constitution. And under the state constitution, it was a per se taking, right? No amortization period is ever reasonable. There was a concurring opinion that said, well, the 30 days is too short, but a more reasonable period can be permissible. So then you can cite the concurring opinion saying that a longer period might be okay, but 30 days is probably way too short.
Wait, so it was state though? though, so if it was a constitution, like federal level, then I couldn't use that case?
I don't think that's a federal rule. That's correct.
Oh, okay.
Yeah, the Pennsylvania case was brought in the Pennsylvania Constitution. So just keep in mind. But I think it's a good common law rule. And between the majority and the concurring opinion, you have two different perspectives. Okay, other questions on number 2? Nothing on number 2? Going once? Going twice? All right, I'll move on. Look at number 3. Oh, this one's a little bit long. Okay. In 1895, by the way, on my exams, people live a very long time. Unless I say they're dead, they're not dead. In 1895, Voldemort granted Dumbledore an easement on Crossacre for the purpose and with the right of constructing, maintaining, and operating a railroad for public use in the conveyance of persons and property by the power of steam or otherwise. So what we're going to have here is a question where an easement's granted many, many years ago, and the purpose of that easement may have passed with time. For more than 80 years, Dumbledore operated the Hogwarts Express, a steam locomotive that traveled on rails across Castleacre, transporting passengers and property. However, in 1977, Dumbledore stopped operating the Hogwarts Express, but he left all the rails in place. Okay. Longevity is very long. 40 years later, in 2017, Dumbledore decided to resume operation of the Hogwarts Express with a new magnetic levitation technology. Using powerful electromagnets in the bottom of the cars, the train would float 1 inch above the already installed rails and quickly glide forward or backwards. Voldemort files suit asking the Supreme Court to enjoin Dumbledore from relying on the 1895 easement to operate the Hogwarts Express. So here we have a case with an easement that's quite old. And first question is, was it abandoned? Right? Was the decision to stop running the railroad mean the easement's abandoned, in which case it reverts back to the grantor, in this case that'd be Voldemort. It's complicated because he stopped running the trains, but he left the rails there. Okay, is there abandonment? Again, I can go either way on this one. I don't think I have a correct answer. The next question is, does the easement then continue with respect to the hover train, the magnetic levitation train, right? So it's actually a harder question, I think. Is there a trespass if you float above someone's land? Right? I mean, technically you're violating their air rights. And this is an easement for surface rights. So does it even cover air rights? Because you're you're 1 inch above the property. So I think it's actually a very hard question because you have the air rights issue, which wasn't really talked about in the A+ answer. And then the final issue is, can a court sort of update an easement, right, based on the changing times, right? We did this one case where we had a community that was very residential, and then it became much more commercial, and they asked to update the easement. They said no. Then you have the feedlot case where you can have a coming to the nuisance, and you can sort of change the character of a neighborhood. So I can go either way, but I think an important aspect of this question is, was the easement abandoned? Does the easement cover the air rights, which is right above the surface? And also whether the court can modify or update the easement. Now, the A+ answer here will not make a lot of sense to you because there was a case in your book, which I referenced, but they cut out, called Persault. But I think it's still good enough. Even if you don't know Persault, it's still good. So they wrote.
So I
Yeah.
thought you talked about like the rails and trails. Is that the one?
Yeah, that's the case. It got removed from your book.
Okay, yeah.
I like it. It was a good case, but they took it out. Did I talk about it? I can't remember.
Yeah, you did.
Yeah, I did. I sent the author of the book a note saying I like that case, but they don't listen. All right, so let's read. It says, there is no dominant tenement. That's correct. This is an easement in gross, right? It's an easement for the benefit of a person. Okay. Since there's no dominant tenement, Voldemort, the grantor, conveyed the easement to Dumbledore, the grantee, as an EIG. Oh, okay. Easement in gross. There you go. if there was an intent to be bound and there was a land transaction involved in the conveyance of EIG, because unlike the modern law, under the common law, an EIG can't benefit a third party without a land transaction. Okay, imagine reading like 90 of these. It gets very tough, but you do your best, right? So what they're saying here is that you can't benefit a third party with an easement. I don't think there's a third party here. I'm not sure why that's relevant, but it's correct. If there's a transfer of land, or the court uses the modern law approach under Persault, here we go, finally. Voldemort will argue that Dumbledore abandoned the easement and it was relinquished. I think he mean abandoned, relinquished, yeah. But under Persault, there must be a non-use coupled with an act manifesting a present intent to relinquish the easement. He never removed the tracks, which I think is important, or expressed any intent to relinquish it. Okay. Even though he's still using this new technology, it's within the original intent of the easement, a form of conveyance, perhaps. It goes back to this. There's no land transaction coupled. I think it's confusing this with covenants, actually, because you don't need the land transaction for, there's no horizontal privity for easement. So I think this person's confusing those topics. New technology, blah, blah. Anyway, it did mention the air rights. So again, I think what's going on here, if I remember, is a student actually thinking of horizontal privity and covenants, but that's the rule for covenants, not for easements. So trying to conflate those rules for your exam. Again, this was A+, so there's no perfect. So questions on number 3? Yeah. Question number 3. No? Okay. All right, so number 4. Okay. Here we go. Oh, this one gets to the air rights question as well. After some successful lobbying by Dumbledore, the legislature promptly enacts a new law amending the Trespass Statute. Quote, it shall not constitute a trespass when one temporarily floats at least half of an inch above property. So it's not a trespass to hover. Okay, in other words, people can hover as much as they want. Why is that significant? Because you had in the past an air right that people would not trespass over your air. And by virtue of the statute, that stick in your bundle was snapped in half, right? This statute removed one of your air rights to prevent people from trespassing above your ground. So now anyone can just float half an inch across your property. Try building a house. If, half an inch up, they can zip through it. Okay? Dumbledore begins to float the Hogwarts Express 1 inch above the rails on Crossacre on a daily basis. Voldemort brings suit, alleging that the new law violates the Takings Clause of the Fifth Amendment. And again, regardless of how we answer question number 3, how should the court resolve Voldemort's claim based on the Fifth Amendment's Takings Clause? So we have to walk through our framework. This is a good review. Walk through our framework for a Takings Clause, right? So first we ask ourselves, has there been a physical taking, right? Under Loretto, has there been a permanent physical occupation? And this is something a little different, right? There's nothing physical. It's all about floating. So there's certainly not any sort of physical installation, right? The government's not making you install a cable wire on the side of your building. So then we ask, our next step, yeah, Kendra?
How would a train not going every day over your property?
Over.
The rails, though.
The rails were already there, right? The rails were there for years.
The rails are required for the train.
So the question here, no, they're not. It doesn't say that. You're reading facts on evidence, right? They're floating above the rails, but they don't need the rails, right? The statute here is, does the statute constitute a taking, right? It's merely saying is, does the elimination of the trespass cause of action, does that constitute a taking? Right? In other words, you had a right to evict trespassers before this statute, and now you don't. Is that a taking? Okay, yeah.
Well, then if they're not physically touching the rails in the land, then how does it touch or concern the land more so relating to the third?
Well, touch and concern, but that goes to question 3, right? Originally, you had an actual railroad, and the easement concerned a railroad. So I think a good answer to number 3 is you can't, maybe it's a very good answer, you can't extend the easement to a hovercraft because it doesn't touch and concern the land literally, right? Although under the Ponza case, touch and concern doesn't mean literally touch. It means, does it like deal with the land? So I don't think that goes too far, but I think it's a very creative thought on question number 3. Okay? Let's talk about question number 4, right? When you're asking about a taking question, first ask, is there any sort of physical taking, right? Is the government making you install something on your land? And the answer here is no. Okay, so next we ask ourselves, is the government diminishing 100% of the value of your property, right? Is it complete taking of value? I think the answer here is probably no, right? You can still use most of your land, but they are diminishing it. Okay, so we ask, is there a nuisance, right, under Hadachek? Justice Busby mentioned this last week. Is there a nuisance that's being policed? Well, at common law, you really didn't have hovercrafts, right? So it's not really something that common law would care about. So you don't have a complete diminution in value, right? So it's not like Lucas, where you can't build on your beachfront property. And you don't have any sort of nuisance. Then you go to Penn Central, right? Our favorite case, Penn Central. And we ask ourselves, you know, were there certain distinct investment-backed expectations here? So here the railroads actually may cut the other way, right? The fact that you had railroads there means you wanted trains to go across the land. And if you have a hover thing zipping through the air, you can't have your railroad business. There actually might be a decent Penn Central case that you've had a long-standing property interest, right? You've built these rails. They've been there for a long time. Maybe the easement relinquished back to you, and now you can't use it. So I think here there's actually a decent, Penn Central claim. But also keep in mind Wisconsin versus Murr, right? What is the correct denominator, right? Are we talking only the land above the railroad tracks, or you have all this land you can put they can fly somewhere else? So I think under Penn Central and Wisconsin v. Murr, you might be able to make a case, but probably not. I don't know that this law would actually amount to a taking, but I think those are the cases that you should probably walk through, right? First, you got Loretto, then you have Lucas, then you have Hadachek, then you have Penn Central, then you have Wisconsin against Murr. With five cases they should probably work through in your answer. Let's see what my A+ student last semester did. Okay. I think I got most of them, yeah. The Fifth Amendment requires just compensation when private property is taken for public use and can be defined as either regulatory or physical taking. Good. There is no physical taking by the government like Loretto because nothing is physically being attached to the property. Good. Again, the tracks were there. The government's not attaching them. Therefore, you analyze it under the regulatory approach. The regulation does not result in diminution of value under Penn Cole. Oh, sorry. Yep. The regulation does result in a diminution of value under Penn Cole. That's correct. But it's not a complete diminution of value under Lucas. Correct. Because the trains come and go, and Voldemort can still make use of the property. That's very good. That's what I want you to see, right? You start with Loretto. Penn Cole's good, but I'll go to Lucas then. So since we don't have a complete diminution in value, you analyze under Penn Central. They didn't do Hadachek, so not perfect, but you should be working Hadachek at the next step into your analysis. Since this is not a complete diminution in value, this must be analyzed under Penn Central. Good. Viewing the parcel as a whole using the Murr denominator test. Good. Crossacre is only being affected by part of it with the railroad tracks, and like in Penn Central, Voldemort has made no dibbies. I don't think that's right. And any losses will be future speculative losses and doesn't require compensation since it's within the police power. Not right. We do not know how the land is bounded, much about specific characteristics or effective value and change, but a reasonable landowner would anticipate crossacre as one parcel. That's the Murr question with the denominators. So that's pretty good. Not everything's perfect, it's pretty good. So again, Loretto, I think you have Lucas and Penn Cole, then you have Hadachek, then you have Penn Central and Murr. I think those 5 principles you should be talking about in any takings question. So you have a good framework to walk through here. All right, question to number number 4. Question number 4. No? No? All right, move on. Okay, last one is always our policy question. Okay, so frustrated with the situation. I'm Crossacre. I have a typo there. Sorry about that. Voldemort begins to chase Potter, his longtime foe, with the intent to kill him. Potter, a wizard, can make his broomstick fly. While escaping Voldemort, Potter flies on his broom from Castleacre across a park and back to a store on Alleyacre. Potter ignores a sign at the entrance of the park that says no vehicles in the park. After he lands on Alleyacre, he's arrested for trespassing, right? How should the court interpret the sign that says no vehicles in the park in deciding whether he's guilty of trespass? So this question has an additional element, which is not really property-ish, but I think it's important, that he was basically running for his life. I do think that does factor into the question. Sort of going back to last semester with State v. Shack, right? How important do we hold property rights when life is at stake? And are we willing to enforce rigidly a trespass statute when a person would otherwise be killed? I do think that, it's sort of a crim question, but it focuses more on how important are property rights in this case. Okay?
Would you expect us to add that in to the answer?
Yes. Yes. Yeah, that's why I said it. Yeah. So the question of no vehicles in the park is one we discuss at length, and how you describe a vehicle is fairly open-ended. I think we spent 20 minutes discussing this. I don't want to rehash it, but it's a classic law school chestnut. All right. Oh, this was good, yeah. So the sign, no vehicles in the park, is unconstitutionally vague under the DP. That's due process. Josh, we never did that. Yeah, we actually kind of did. If you remember, we had the various zoning cases where, what do you call it? The zoning laws said that, you have to have things that are like aesthetically pleasing, and, they're these very vague standards. No one knows what they mean, right? When you have these vague signs, there's actually due process problems. So if people can't understand what the law is, there's actually a problem of due process. So maybe it's a good answer that the sign's so vague, you can't know what a vehicle is, you can't be then guilty of trespass. So it says, it shouldn't be enforced in the void for vagueness doctrine. Very good. People have a right to know what the laws, and a reasonable person should be able to understand what the sign means. Without a description of what constitutes a vehicle, the trespassing claim should not be enforced. Well, that's also good. Additionally, in the park, it's also vague since Potter never touched the ground. It only flew above it. What does in mean? Good point. I didn't think of that. It's a good point. When an airplane flies over a piece of property, there's not a trespass. That's not necessarily true. There's some old cases holding that airplanes do violate air rights, but that's no longer the case now. Potter will argue he was never in the park. Okay, again, void for vagueness. I'd like to actually discuss whether broomstick's a vehicle. I think that would have been nice, discussing what is a vehicle, how to understand it. We have a lot of time on this. Is a form of conveyance, etc. So that sort of thing I think would have been a little more helpful. Again, this is a decent example. This is probably straight 9s. Maybe, I don't think there's any 10s here. Maybe 110. If I had to guess, probably a 44, 43, if I had to guess what this was. Not a 15. Okay. Questions at number 5. Question number 5. Nope. Okay. Anything in the exam as a whole? I have not written your exam yet. I have no idea what's on, so don't even ask me. I deliberately don't write it until this is over because I'm very bad with keeping secrets. Yeah.
Did you say that variances run with the land?
Did I say that today?
No, I meant like in general. I can't remember.
Well, a variance exists so long as the hardship continues to exist. So if the variance is based on the occupant, I think of the wheelchair ramp, right? Then if the person moves out, I don't think the variance sticks around. But the variance is based on, say, you need to have a certain number of feet to the sidewalk, and they give you a variance because of hardship. I think that would then continue from owner to owner. I wouldn't say run with the land. I've never heard that phrase used in this context, but I think it goes from owner to owner. Okay. What else? What else, guys? Going once. Yeah.
Question. I guess this will go back to over the Pennsylvania Northwestern Distributors case, and how we have the two different standards, and how you did say it was based off a state. When faced with a question like that, I believe in class you said the concurrent was the majority view.
I think that's probably right.
And
Yeah.
that
Yeah. The majority is the outlier. Yeah.
the outlier. So is that the way we should face it? If we
I wouldn't expect you to go that far. I'd accept either answer, but to be precise, the majority rule is probably the concurrence. So if you want to know what the common rule was, you need to have a reasonable amortization period. I don't think 30 days is reasonable under any standard in any state. I think you need a couple years to give people time to wind down their business. So I think that's probably that's like the best answer if you want to get what's a 10. But if you said under the rule in Northwestern, all these are per se confiscatory, then I would accept that just the same. But I think I did mention that. Can't remember if I mentioned it last year. I don't even know. Other questions? Going once. Going twice. Thank you all for a wonderful semester. Appreciate it. Thank you.